We want to talk today about high-risk AI systems, and we decided to talk about this topic because in the different jurisdictions there are different thoughts about regulating AI systems, and in particular high risk AI systems. And it's very important for providers and deployers to know and to understand how the different jurisdictions are actually trying to regulate or intend to regulate such systems. And this is why we now or today decided to open this discussion and want to provide you 5 examples, including the European Union, Latin America, India, Southeast Asia, and UK, in order to show you how different the legislator is actually trying to regulate this very important topic. So our first speaker today is Valentino. He's attorney and partner at Oppenhof. He has specialized in tech, data, cyber, and AI law, and he advises national or international companies when they implement AI systems and when they also use AI systems. And in this function, he today is the best speaker who can present to us the thoughts of the European Commission about AI systems with high risks for the natural persons. So please, Valentino, start with your presentation.
Yes, will do. Many thanks, Sonja, for the nice intro. So given the tight timeline, I guess we have, like everybody of us has perhaps 10, 12, 13 minutes. Let's jump into the matter. Perhaps the first question. So my topic is high-risk AI regulation under the EU AI Act. And the first question is perhaps what are the key dates for the general timeline in a nutshell, because something changed here. So on 1st August 2024, the EU AI Act entered into force after its publication in the official journal of the Union. And that's entry into force date. But the picture has since changed materially because the digital omnibus on AI postpones the core high-risk obligations. These core obligations will start later to apply. So if we look at the other end of the at the timeline on 2nd August 2026, this year, a few days ago, most, let's say, transparency obligations will start to apply. But requirements for high-risk AI requirements will start only to apply on 2nd December 27. The high-risk obligations for Annex 3, meaning standalone AI systems, will become applicable. And 1 year later, on 2nd August 2028, the high-risk obligations for high-risk AI systems that are products or safety components of certain products will kick in. This is Annex 1. And for companies, this means that they should already have started, or should at least start now, to implement the requirements. And so they have a little bit more time for implementing the requirements, and they should not pause implementing. The first slide is perhaps let's say an overview of the concept of the UAI Act. So the UAI Act is a preventive prohibition law, meaning that the use of AI systems is prohibited or subject to certain requirements, in a large number of cases. And secondly, and most importantly, the AI Act follows a so-called risk-based approach. In other words, there are few categories of AI systems according to the degree of risk involved, and the UI Act puts or sets forth certain requirements for those risk categories. So there are a few. In the first line, we have unacceptable AI practices, meaning AI systems or practices that pose an unacceptable risk and are therefore completely prohibited. For example, social scoring or manipulative chatbots, for example. And then we have AI systems associated with a high risk. Post-classification as a high-risk AI system entails extensive obligations. This concerns, for example, HR software, what we will talk about that later. And then we have other AI systems with limited risk and also as a special category, general purpose AI. The latter or the two latter categories are not our topic, the topic of our discussion today. So, and then perhaps the next slide. So we can ask the question, how are AI systems classified or qualified as high-risk AI systems? So the AI Act follows a use case-driven risk-based approach, and a high risk classification set out in Article 5 in conjunction with two annexes of the AI Act. And so there are, let's say, two independent pathways leading to a higher risk AI classification, and it's important to distinguish them clearly at the outset. So the first one, Article 6.1, in conjunction with Annex 1, means or is an AI system itself is a product or a safety component of a product covered by union harmonization legislation listed in Annex 1 and required to undergo a third-party conformity assessment. This applies, for example, to elevators, to certain machines. But also, so perhaps these are very important examples. And then the second one is a second pathway is Article 6.2 in conjunction with Annex 3. The AI system falls within one of the 8 domains listed in the said annex. For example, biometrics, critical infrastructure, education, employment. I think this is the most important for all companies, because every company has an HR department, and other areas like law enforcement, migration, asylum, which is not that interesting for private sector companies, I think. And then we have also, let's say, under Article 6.3. Even if a system is listed in one of the annexes, it is exceptionally not treated as high-risk AI, where it does not pose a significant risk of harm to health, safety, or fundamental rights. But the provider in this case must document that self-assessment and register it in a EU database. And the digital omnibus, now this is one of the, let's say, reliefs, narrows the concept of, for example, safety components. I put this on the slide. For example, AI features used merely for assistance, optimization, efficiency, or convenience are not automatically high-risk AI if their failure or malfunction does not create a health or safety risk. And the AI Omnibus also, that the AI Omnibus is the recent reform of the EU AI Act, reduces overlap, meaning, for example, machinery products with AI components no longer face, let's say, duplicative procedures, meaning under machine regulation and AI Act, provided the applicable sectoral safety rules ensure an equivalent level of protection. Yeah. And perhaps one last thing, classification is not static. Yeah, Annex 3 can be amended by a delegated act under the AI Act. So providers and deployers must, let's say, monitor Commission's updates and forthcoming classification guidelines. Yeah. And perhaps then the second question, next slide, please, is, what are the, let's say, if an AI system or a use case of an AI system is qualified or is found to be a high-risk AI system, what are the key obligations for high-risk AI? Especially so for the providers, meaning, let's say, the manufacturer of an high-risk AI system, and a deployer, meaning a commercial user. Requirements for high-risk AI system itself, primarily addressed to the provider. I think one of the main things is risk management system. This requires, identify, estimate, evaluate, and mitigate known and reasonable foreseeable risks from the intended use or use case, or a reasonably foreseen use case, foreseen misuse. Then we have also something very important is data and data governance. This Article 10, this relates to training, validation, testing data sets. So they must be relevant, sufficiently representative, and as far as possible free of errors and complete. So I think these are very high standards or very strict standards. And providers must examine bias and coordinate with GDPR limits or requirements. And then we have also let's say, other requirements like technical documentation, logging, transparency, instruction, human oversight. Article 14 is also an important requirement. So the system must be designated to enable effective oversight, and meaning monitoring, anomaly detection, correct interpretation, non-use of unreliable outputs, and the ability to intervene, and override or interrupt the system or the output of the process of the high-risk AI system. And so these are the requirements regarding the system. And then we have also provider obligations, especially maintaining a quality management system throughout the whole life cycle of the AI high-risk AI system, performing an applicable conformity assessment, register a system in the EU database for high-risk AI systems, keep technical documentation, etc. So it's a long and strict catalog of requirements and obligations. And when it comes to deployer, so if you only, let's say, buy a high-risk AI system and use it within your business activities of your companies, then the use of the high-risk AI system needs to be in accordance with the provider's instructions for use and only for the intended purposes. We need to assign human oversight to natural persons who have the necessary, let's say, competence and training. You need to ensure that the input data and the deployer's control is relevant and sufficiently representative. So it's again related to data management and quality. You also need to keep automatically generated logs where they are under the deployer's control. You need to inform affected persons, and where applicable, also, for example, workers, representatives, and in some but limited cases, you need to conduct a fundamental rights impact assessment. That's, I would say, something similar, of course, not the same as a privacy impact data privacy impact assessment. And I think so. This should be enough for the key obligations. And then perhaps, we can perhaps go to the next slide. So in question or in the practice or in practice, I think the main question for companies is, how or which specific steps and measures companies must take or implement in order to meet the described requirements. And in this context, the concept of technical and harmonized standards and the new legislative framework is decisive and maybe of help. So, because as part of the new legislative framework, legislative technique at EU level, essential requirements of the EU AI Act are standardized by means of harmonized standards or norms in order to make the, let's say, abstract regulatory requirements more operational for companies. And these standards are currently being developed by the European Standardization Organization, CEN and CENELEC, based on a standardization request of the EU Commission. And they are to be recognized by the EU through publication of an official journal. And a first draft version of the standards was expected in early 2026. And now, not a year, but more than a half year later. So at least, in the last few weeks, the first parts of the standards, harmonized standards, in a draft version have been issued by the standardization bodies. And the concept is companies can voluntarily comply with these harmonized standards. So it's not they are not obliged to do so. But if they implement the standards, the EU AI Act presumes that the company in question meets the requirements of the EU AI Act. So, meaning this is it's called presumption of conformity. And these standards, when they finally come into existence, they will provide companies in a way, a relatively high degree of legal certainty. And I think the next slide we can skip. The slide only displays a few areas which are subject or part of the harmonized or upcoming harmonized standards. So I think these are the very, very in a nutshell, the basics of high-risk AI regulation under the EU AI Act. And with this, so I hand over to Emily, who will provide us with an overview of high-risk AI regulation under UK law. Thanks.
Thank you, Valentino. We all know that in European Union there is much regulation about AI systems, and in no other country there is so much regulation on this topic. So now even if the UK is also in Europe, I think it's a completely different approach, which now Emily will present us. So please, Emily, go forward. Emily?
Sonja. Yeah. Thank you.
So, sorry. And for anyone, if anyone doesn't know Emily, but I don't think so, but for the ones who do not know Emily, she's associate with CMS and in the technical and technology and media team. and also advises, as we all do, in artificial intelligence and technology contracts. And so now she gives us this overview about the UK legislation.
Thank you, Sonja. So UK approach is very different from the EU approach that you've just heard from Valentino. Biggest contrast when it comes to high-risk AI is there are no explicit regulations that cover AI as a whole. So there is no one piece of legislation that says it regulates all of AI in the UK. It's much more piecemeal than that. And that hasn't been the government strategy going forward at the moment. So that also means that we don't have one regulator either. There's actually lots of different regulators that could be involved with AI depending on how AI is used, and also depending on the risk of that AI, if we're talking about high risk AI. It's also worth putting out front, there isn't really a definition of high risk AI in the UK. So when I'm saying high risk, I'm not necessarily referring to the same as the EU AI Act definition. I'm more talking in general of risks that AI could cause harm to someone or financial damage to someone, that kind of thing. More general sense of high risk is what I'm talking about here. So the bit that is similar to the EU is we do have data protection regulations, which are still fairly similar at the moment, although changing. And I'm going to talk about one of those changes in my slide in a minute. So that does cover AI so far as it involves the processing of personal data. And then other than that, you've got this kind of very sector-specific approach. So one of the ones that's really worth drawing out is the first one I've got on the list on the slide is AI and financial services. That's a sector that's very forward in the UK in terms of putting together regulator guidance and legislation, because it's a very consumer heavy area. It's an area where there's a lot of AI being used at the moment, and therefore there's a lot of guidance from the regulator in that area about how to use AI. So that's sort of an area that's seeing a lot of it. And you could say financial services is in some way a high risk area, because if things go wrong for the consumer, then they might actually cause them some damage in terms of lost finances. I've got on here some other examples of where we're seeing different regulators. So AI and cybersecurity, that generally gets overseen by our information commissioner, which looks over data protection. Medical devices covered by a totally different area. AI and online content. You may have heard that in the UK we've got this act called the Online Safety Act, which manages different ways that users can interact with each other on the internet and aims to protect children and to protect users from harmful content. That's actually overseen by the same regulator that manages telecoms in the UK, who also oversees the use of AI and telecoms. And then you've kind of got this idea of product liability, advertising, which might fall under more of a general consumer regulator or general advertising regulator. So as you can see, it's really a kind of a piecemeal of approach. And in terms of whether high risk is managed is really on the basis of the laws and regulators that already exist. So moving on to my next slide to talk about specifically the data protection aspect. Could you do next slide, please? Perfect, thank you. Oh, lovely. So I mentioned that one thing that is covering the UK, which is fairly similar to the EU, is the approach to data protection. And anyone who's familiar with EU, the GDPR, you know that Article 22 exists, which covers automated processing, including profiling. So what I want to highlight here is actually this, it has been a big area of change in the UK recently. So the old Article 22 and how it still is in the EU is that generally there is a prohibition against automated processing unless certain criteria is fulfilled, where that criteria is normally explicit consent or contract or authorised by law where there is a substantial public interest. The UK has actually enacted something called the Data Use and Access Act in 2025, and that has somewhat softened our Article 22. And what it essentially does is it now has a two-tier system. So it's taken away that general prohibition. And what it instead says is actually that previous way act only happens when there's special category data at play. But anyone who works in data protection knows that special category data doesn't always equal high risk. So special category data is going to cover things like race, beliefs, whether someone's part of a trade union, sexual orientation. I haven't listed all of them. But what it doesn't cover, for instance, is financial information. That's not one of the listed parts of special category data. So we now have a situation in the UK where you could have some automated processing, which could be under a more general reasoning under the UK GDPR. So the new Article 22 says that where there is no special category data, then actually that general prohibition is lifted and any legal basis can be relied upon, just like any other data processing. So that means that a company could justify it as long as there's no special category data with legitimate interest. It does still mean that the protections are in place. So there's still the protections around providing information, allowing data subjects to make representations or contest decisions or ask for human intervention. That still sits there. But the general barrier for companies to use Article 22 to do some automated processing, whether it's personal data, has become somewhat easier in the UK, which does have an impact on to what extent we really are regulating high-risk AI on a more philosophical level. So that's one aspect I wanted to mention. Another quick thing I wanted to mention about the UK, even though we don't necessarily have an approach to high-risk AI as a whole, is the UK Justice Task Force recent paper. So if we go on to my final slide here, slide number 3, please. The UK Justice Task Force is an organisation that has looked at our kind of current laws, thought about whether they're adequate or not, and they recently put out a legal statement on whether they felt that AI liability in particular was particularly accounted for in UK law. And they came to the conclusion that actually it was covered mostly by UK law. They said that AI liability outside of issues around data protection can set normally within contract or negligence, or we call it sometimes tort in the UK, and that they said was actually sufficient. So that's actually got a knock-on effect to what we might think about high-risk AI as well, in that how is that really going to be managed in the UK? Actually, the position at the moment is it's going to be managed through existing legal mechanisms. And they go into great detail into this paper, but there's a lot of what ifs and if this and if that. And essentially, they were saying mechanisms, a little bit more creative legal thinking there. So things like vicarious liability, where you have an employer and employee relationship, an employer might take on some liability. Or they talked about things like professional duties, the duties that we have as lawyers or accountants to our clients, and how we might take on liability in that aspect. So there's a lot of kind of thinking around existing legal mechanisms and how that would act out. And there's also a lot of thinking about causality and how that applies, looking at supply chains, who is the deployer, who's actually providing the contract to use AI, and who is the kind of ultimate person at play in that decision-making process. So that's what this paper is doing. And it's just got a quite interesting high knock-on effect, thinking about, well, what is high risk and how would the UK really deal with it? So that was, I am relatively quick compared to the EU because we don't have an overall AI legislation. So that's the UK really in a nutshell. And if anyone wants my contact details, then it will be on the last slide here.
Thank you, Emily. I would have additional questions, but we decided to collect all the questions and then to discuss your presentations and the questions in the last 10-15 minutes. So thank you, Emily. And now we move forward to the presentation of Diego. I don't think I have to introduce Diego. He's the immediate past president of the ITechLaw Association, and I think everyone must know him, and so it's not necessary to introduce him. Diego, please give us your presentation about the regulation or the approach of Latin America to high risk systems.
Okay, can you hear me well, and can you see the presentation, Sonja? Okay. Thank you. I'm really happy to be on the webinar and one of the activities of the AI committee that you are chairing. Thank you for inviting me. So my I will try to be short also, so that everybody has enough time. And we might have some questions. The idea was that I would cover Argentina and also some selected countries from Latin America to give a little flavor of what's going on in Latin America in general. Unlike the EU and the UK, the news here in Latin America are different. So as you will see from my presentation, the development of AI regulations is still in an early stage. I don't think that we are on an early stage because we don't know what to do, but rather I think that in Latin America there's interesting discussion seeing what happened in the EU and what's going on in the US as to what we want to have, where we want to be. So there's a discussion on countries that, countries in Latin America needs investment and development a lot. And I think that this area is one of those in which the decision that you take has a lot of impact. And so there are strategic conversations and discussions on this specific topic because we want to make sure that, or the governments wants to make sure that the right incentives are in the right place. And if we want different companies from the world to be investing in our countries, then we want to make sure that the frameworks that we give them, of course, protecting the rights of everyone that lives here, are the best. So that has to do a lot with what we will be discussing. This is just a snapshot on what you can expect. And I forgot to say, Sonja, that many of our ITechLaw members have contributed and helped me prepare the presentation. There we see their names and logos of their firms in the different slides, and I thank them for that. If we have to divide, I would say that except for Peru and El Salvador, which have some sort of regulation, the other countries that you can see on the slide, Argentina, Brazil, Ecuador, Uruguay, and Chile, do not have a specific AI regulation. In the case of Brazil and Chile, they have pending regulation before the Congress. I think it's uncertain whether they will pass and when. That's how it works. But for the time being, we do not have a specific regulations in most of them. What about Argentina? So Argentina, as I said, there's no express regulation. The different aspects that we see that make some kind of connection with AI comes from the data protection law, mainly talking about automated decisions. There's no much on that, but as we say, and I think this is important also to discuss, those countries that do not have a specific regulation doesn't mean that you can do whatever you want, and that I think that is obvious. We have a lot of other frameworks that apply, and so our everyday in the firm is advising clients on different AI projects, applying different other regulations. What we don't have, and I think that is something that maybe Emily and Valentino will agree, having the specific regulations that you have heard from them, that's a cost. If you have to put that in place for the companies, that's a cost to have, to have a plan, to be mitigating, to do an analysis, to do a mapping. So we don't have that for the time being, and that's something that in certain cases it might be an advantage. Of course, the downside of not having that specific regulation is that in certain cases you might be using AI in a way that could affect the rights of others. Of course, you have different regulations that you can resort to, but it's different if you have something specific in which we have to be accountable for before doing that. So as I said, in Argentina, we have the data protection law. We have a very well-developed civil liability framework, which we use all the time. Consumer law is very highly regulated in Argentina, and it's very pro, I would say, consumer. So it's something that you have to take into account. Employment, when you're talking about deploying AI in an employment environment, which is very common mostly used today for hiring or doing assessment of your employees. If you use AI tools, you have to have in mind certain aspects there. And then, of course, IP. IP, I think in the region, we don't have a development of the many open questions that you have in the intersection between IP and AI, whether you can train an LLM with with IP protected materials. Even we don't have specific cases on the data protection side, whether you can use personal data to train them. What about the output, the input? So you have to have that in mind, but for the time being, there's no specific. In what comes to policy, I would, and I'm not going to cover every aspect of the different slides. You will receive a copy of them. But what I will say, if we have a ministry of deregulation, something new for Argentina, and you can see from the name that they are deregulating. So the minister said in one of the many forums, I think it was a G20, that he was part of the administration to make sure that there's no AI regulation, express AI regulation for the time being. So you can see where Argentina is going, and many other countries in the region are have a similar path, I would say. And what we see is there are certain bills pending before Congress. Most of them have to do with, as I said, data protection. There's no specific AI for the time being, but that could change. That can change, and as we will see when we get to Chile, the political environment in Latin America changes over time. Normally every other 4 years, you might have a different administrations, and so what today's what people are following might change in the near future. So we need to be following different bills that are presented with Congress. To finish with Argentina, I would say there are certain sector guidance, like the Bar Association has specific guidance for us lawyers, or you can see the central banks have specific guidance if you are using AI in the financial institution sector. But other than that, there's no much yet. And most of them, not the central bank, but most of the others are just soft law, good practices, but normally non-enforceable as such. Moving to Brazil, and I'm thanking our good friend Fabio. Brazil has an AI regulation which is pending before Congress. There's no certainty yet when and how it will be passed, if it is passed. But similar to other countries as Argentina, most of the regulation has to do with AI comes from the data protection law. Brazil has a similar regulation to GDPR. They have their own LGPD with very high fines and very specific obligations. And what I will add from Brazil is that they have the regulator has identified AI as a priority, and they have launched an AI regulatory sandbox within the ANPD. And so we might see different projects going there to that sandbox before hitting the market, which I really think is a good practice. If you go to Peru is one of the few countries that have a specific regulation. They have certain laws in force, similar to regulations in the EU. It's a risk model. They have a tier 1, 2, and 3. You can see they're prohibited or improper uses, high risk systems, unacceptable risk. Of course, depending on the category where you fit, are the obligations that you have. And I guess that's similar to what Valentina was telling us on the EU. So Peru, if you are planning to do business in Latam and one of those countries is Peru, you really need to take a look to the specific regulations on AI that they have. And I let the names and the firms that contributed there, so that if you have any other doubts more deeply than what I'm explaining here in 10 minutes, you can reach out to them. All of them are experts on this specific topic. El Salvador is the other country that has some kind of regulation, but it's different from what we know. This is triggered by use. So if the AI system is making consequential decisions, understood as having a very important high impact on persons living in El Salvador, there's a registration requirement. But that is triggered, as I said, by use, and then you have to be on what they call these sensitive domains, which include health, finance, biometrics, public services, employment, and education, which I think is a pretty broad domain. There are many AI systems that we see in the market that would fall into this category. So the only thing for the time being is the regulator, which is the National Artificial Intelligence Agency. They have a registry, and they might ask follow-up questions when you register on what you are doing, whether you are where the risks are, whether you have a mitigating plan for certain risks, etc. So El Salvador is another country to take a look at. When you go to Ecuador, Ecuador has no specific AI regulation. They have a very similar new data protection law, similar to GDPR, very comprehensive and complex. And so similar to what we have seen in Argentina and Brazil and other countries, most of the regulations that would apply to AI systems comes from their data protection law. Automated decision, risks, information, transparency, all of them that you already know. In the case of Uruguay, it's very similar, I would say, to Argentina. We just came back last Thursday. ITechLaw organized a workshop we call cyberspace camps in Uruguay, and I was there. And the responsible ministry from the government for innovation was there, presenting what they call Uruguay Innova, which would be in Uruguay's innovating. And they think that specific AI regulation is not needed at the time. They are happy with applying general principles of law and other laws. But similar to what I was saying about Argentina, they want to make sure that the framework is favorable for the investment. Of course, protecting rights. They have a very the regulator there, AGESIC in Uruguay, is very on the different topics and very on protecting the rights when it has to do with data protection. So they are doing a really good job. Moving to Chile. Chile is an interesting case. They do have a bill, an AI bill pending before Congress, but as I was saying, when the governments and the administration changes, the new administration have just said that they are announcing a substitute. That's the word, and it could mean many things. But this substitute would change what they have before Congress. The text is not yet made clear, and it's not disclosed to the public. But they are trying to find a more friendly innovation approach, similar to Japan. That's what they say, what the news reflect. So we might see some new rules coming from Chile. As you might know, Chile passed data protection legislation, which had a 2-year period before entering into force, but they are now saying that they might push back a little bit that deadline, and so we're not sure when we will see changes in Chile. So that's what I want to cover. I don't want to. I'm almost 13 minutes, Sonja. I will give it back to you. There's a slide where what you should know before doing business in Argentina that might be good for people to receive. But other than that, happy to be. Thank you.
Thank you very much, Diego, for the overview of all the different countries in Latin America. Thank you very much. And I think any additional questions we really should then present in the last 10 to 15 minutes. So now is our next speaker, and I'm really happy to present her to you. She's partner of Tilleke & Gibbons, based in Bangkok, and she leads the firm's regional TMT group within Southeast Asia. And her main areas also include data privacy, cybersecurity, AI, fintech, payments, and technology as well. And today she will introduce to us the approach of Southeast Asia. So thank you very much, Nob.
Hey, thank you very much for the introductions, and thank you for having me on this panel. So
welcome.
I wanted to talk about like something that has changed very quickly, which is really AI regulation in Southeast Asia. if this panel were to happen like a year ago, it would be just 1 minute for me to say that we have nothing. A year ago, no countries in this region, which we have 10, have no standalone AI law. The approach was very soft and it's very like voluntary guideline, non-binding principle, particularly wait and see. But for the past 6 months, it's no longer the case. Vietnam is the first country that has passed the law. It's a full AI law, and that's the first in Southeast Asia. And then I think for Thailand and Vietnam, we are kind of like competing each other. So Thailand also has a draft AI Act, and they have introduced it for public consultation, and the consultation has ended just 5 days ago. Singapore actually is one of the most developed country within the region, but the approach is a bit different. So they don't have a standalone AI law or AI Act, but Singapore is the world first country that issued the governance framework for AI agents. In Indonesia, they're starting to enforce their data protection law, which is quite similar to GDPR. Thailand is also similar to GDPR. Philippines is the same. Vietnam just introduced one, and Malaysia is quite the same. So for Malaysia, they don't have a dedicated AI law as well, but they actually have what is called a National AI Office, and they actually passed specific regulation only about transparency when AI is used in election. And just so you know that the elections, midterm elections of Philippines is coming up here. So in short, Southeast Asia has been very, very quiet, but now I think it's the most active region in about like 6 months ago. So I'll walk through the country landscape first, then like the countries that 10 countries are in this region, and then I will drill down to the 2 countries, which is Vietnam that already have the law, and Thailand that has a draft law that is about to ready to be issued. Next slide, please. So in this slide, you will see that in ASEAN, we talk about the 6 of them that move really fast for the past 6 months, and 4 of them in the last column have not much any move. So starting with the first mover and the quickest one, the leader is Vietnam. As I mentioned, they enact their AI law in December last year, and it took effect in March this year. So everything was very, very, very quick. And actually, the government's when we talk about high-risk AI, let's talk about high-risk AI. The government has issued about this thick of dossier, setting out 46 high-risk AI systems. They also have regulatory sandbox just to kind of like introduce and trying to encourage innovation as well. But the 46 high-risk AI system, the reason of the governments that having it very rule-based is just to make sure that those are considered high risk and will be regulated very strictly, and those who are not in the 46 high-risk AI system designated, then you are outside of the framework. Then we're talking about Thailand. So draft AI Act, actually we have like 2 or 3 drafts before that. The first one was very, very much like the EU AI Act. We have like 4 tiers of risk, and then there's no innovation. And then because Thailand, we change government quite often. So with this new government, then the Minister of Digital Economy he said that he really want to roll out the AI Act. So that's why it is brushed up again, and then now it's become a draft after consultation. Hopefully it will go through the process of the parliaments and of course the endorsement of the king. For Thailand, we are quite a bit of, I would say, quite similar to UK, as we have just heard that we also have the regulators like financial regulators, telecom regulators, Food and Health Authority also issue their own AI guidelines. Even though AI guidelines, it sounds like it's a soft law, but it is the expectation of the regulator that even though for example, a commercial bank, if they do not comply with the guideline, then you might actually in breach of the main Financial Institution Act. So moving on to Singapore, Singapore has no binding AI law, but I don't think they might need one soon, but they are actually trying to lead the AI governance through frameworks. So it is called the Agentic AI Governance Framework, and it is now version 1.5, and the first in the world that's really addressed AI agents that can act on their own. MAS is like the Central Bank of Singapore, has just been super active. They have been publishing an AI risk management toolkit. It happens in March earlier, and a framework for AI agents in finance, just only for like financial sector last month. Indonesia, quite similar to what we have heard from Diego. It is the country that do not yet have AI Act, but it actually enforced the law through their data protection law. So the data protection law against AI system, they has banned what is called, it is very popular here in this side of the world, but I'm not sure if you all have heard it, but they just banned completely what is called Grok, G-R-O-K chatbot. They just banned. So, and again, because in this region, there's a lot of like fraud and scam, and there's a lot of like deepfake chatbot. So that is why right now the government of Indonesia is also looking into coming up with its own AI law. For Malaysia, it's a bit different. So they actually set up what is called a national AI office, and they actually put in 2 billion ringgits to what is called a sovereign AI cloud, and it's rolling out a national AI action plan, and it will go through 2030. The Philippines now sounds like Thailand 2 years ago, that they actually have what is called National AI Strategy 2.0. They have passed their AI election transparency rules, as I just mentioned, and they are now actually developing what is called an AI Development Act. And then another group of countries, Cambodia, Myanmar, Laos, Brunei, do not see anything specific about AI, and you also not see anything specific like GDPR, like regulation. So, but having said all that, it does not mean that you can freely use AI and it will not be in breach of any law. It has the same concept, I think, as we have heard about UK as well, that if it's caused damage to others, then of course tort or wrongful act law will kick in. But again, for those 4 countries, and especially for Myanmar, because right now they already actually had an election, so the government is now up and running, so they are likely to actually following Vietnam and Thailand to come up with their own AI regulation. Next slide, please. Thank you. So I'm going to focus just only for Thailand and Vietnam, because we actually have these 2 countries that have something in similar and have the law, and even though for Thailand it is a draft, but it is a very good shape. So the status, as I mentioned, Vietnam law already in force, but the concept of Vietnam law is different than other country. So in Vietnam, when they issue the law, they will set out all the requirements and obligations, but in terms of enforcement, it will not be in that law. It will not be in that AI Act. So Vietnam government is now in the process of issuing what is called a sanction decree. So sanction decree has to be rolled out, and then if you are in violation of AI Act, then the sanction decree will kick in. Then the penalty can be kicked in. That means even though the law is out there, even though the grace period is super short, 6 months, but the real enforcement has not come yet. So for Thailand and for Vietnam, normally these two countries do not have the concept of extraterritorial, but for AI, it's a lot different. For Thailand, it is very simple. So if you use AI and it affects people in Thailand, it does not have to be a Thai national, but if someone in Thailand is affected, then the law kicks in. And that means you are required to appoint a local representative, which is quite the same concept as GDPR. But for Vietnam, it's a bit harder. So if you provide high-risk AI that is like 74 in the decree or in the dossier, then you need to actually conformity have with the certification. You must set up commercial percent. You must appoint a local representative in Vietnam. So in terms of like business consideration, that is a cost for compliance. And even though we talk a lot about like compliance and everything, both countries, Thailand and Vietnam, still really want to promote innovation. Again, similar to UK, that perhaps just only regulating AI might not be the right approach, and then it might discourage the investment or innovation of AI. So both countries still want to encourage AI, not just regulating. So for Thailand, there is an AI sandbox that the participants who got approved by the regulator then can do the testing. And during the testing, they are exempted from penalty or fines. And for Vietnam, they actually even go a bit further. They have created what is called National AI Development Fund that even gives a tax incentive for AI research and also give existing AI system grace period to really need to actually comply with AI law. And the period is about like 12 months. But for Vietnam, they only focus on very specific sector, only 3, healthcare, education, and finance. Next slide, please. So this one is really the heart of the reason why this region really, really want to regulate AI is because of fraud and scams. And I'm not sure if you're familiar with Southeast Asia. There are several countries that has been called like the king of scams, king of call scam, the fake and everything. So that's why we really need to try to regulate AI, especially for the fakes and chatbot. So what is banned for Thailand? There are 2 things outright. So AI that actually manipulate behaviors to subliminal techniques, or AI that cause unfair discrimination by processing like irrelevant data, large volume of data, that will be prohibited AI. And then we will have what is called a National Thai AI Committee that can add more what would be considered as prohibitions. And they can I don't know if they're going to issue 72 something like Vietnam, but it is wait and see. So for Vietnam, again, as I mentioned, so they actually have high risk, and then they have medium one, and then they have the low one. So, but for the prohibited one, is you have to look into the list as well. And then if in the list, even though I said this is so many AI system, but it actually cut across only 6 sectors: education, religion, ethnicity, healthcare, banking, court, and transportation. And then on deepfake, both countries, of course, are very worried about the deepfake, and it's for good reason as well. So Thailand requires AI-generated content to actually have to be labeled. So the requirement is transparency, especially for content about elections. And this is the same theme as what I mentioned about Philippines, national security and finance, which both of them are the same as Vietnam as well. So for Vietnam, it goes a bit further. So in Article 7, it just flatly prohibited using of fabricated elements of real people to deceive. So it's like completely prohibited. And it goes even beyond, because there is a draft of criminal code that they want to make deepfake impersonation of someone's voice or face as a criminal offense. So if this draft changes of the criminal code pass, then actually Vietnam will be the first country within Southeast Asia that actually carries criminal penalties for deepfakes. In terms of liability, Thailand is the one that is the toughest liability regime. So provider, deployer are jointly liable for AI-related harm, and regardless of whether or not it was their fault. So the defense is very, very narrow. So if it causes harm, but if it is due to force majeure, then you are not liable. Or if it causes harm, but it is because of the victim's own conduct, then you will not be liable. But again, the test of how to say it is the victim's own conduct will be very, very difficult to actually prove to the court. As I mentioned, the Vietnam sanction decree framework is still being finalized. And then we are hoping to see that there will be administrative fine. And of course, if there is incident, they need to be reported to the national AI portal. And then the State Bank also actually draft their own binding regulations for AI in banking as well. So everything is very in parallel, but for Vietnam, it is very, very fast paced. Next slide, please.
Sorry for interrupting, no, but I think we're running out of time. Can we discuss your last slide? Okay, 1 minute. Thank you.
Okay, so then the last thing is that for the whole region, what you have heard is like is everything's in the overview, but don't forget, if you actually going to look into ASEAN country, you make sure that you look into sector specific regulation, and then you actually watch out when the law is come out. So it is in the slide already, so I won't repeat this again. And thank you, and happy to take question.
Thank you very much. Thank you.
You're welcome.
So now the next speaker, my co-chair, the co-chair of the AI committee, Nihao. She is a partner at ITechLaw in India, and no, do not want to waste time. So please, Nihao, give us a short introduction to the Indian regulation.
Sure. Thanks so much, Sonja, pleasure to be on the webinar, and thanks everyone for joining in as well. I'll keep this very, very short, as short as possible, so that we have a little bit of time for Q&A as well. And if I can request that we move to the first slide, please. The Indian experience, I think a little bit similar, lots of similarities and parallels with what we've heard from Emily about the experience in the UK, what we've heard from Diego about what's happening in Argentina, and what we've just heard about what's happening in large parts of Southeast Asia as well. Now, essentially in India, also we don't have a horizontal AI statute. That is very much by design at the moment. That thinking might change and that might evolve. For a while, it was a very strongly stated perspective of the IT ministry that we would not do a horizontal AI statute. There might be some evolution in this thinking. We've got a couple of government committees that have now been set up to sort of see, to sort of stress test this. Should this continue to hold? Should we be thinking about certain kinds of AI regulation, so on and so forth? But what we have for the moment is regulation for specific harms and use cases that comes through a patchwork of different regulations. Again, very similar to a lot of, to what we see happening in some parts of the world. Now, India has always, for a long time now, had a stated position that says we will not necessarily follow regulation of technology as it's happening, in other parts of the world. So we've strongly stayed away from a GDPR style regulation for data protection, for instance, while it does have basic elements that are, say, common with the GDPR. The idea and the ambition and the aim has always been that we need to design legal and regulatory frameworks that make sense for India. Perhaps that work as a blueprint for the global south is again something that you will find the Indian government saying a fair bit of. And that's the thinking that we're seeing play out in India for AI as well. So no horizontal AI statute. This is a deliberate choice that we've made at the moment. What we're seeing is the regulation of different kinds of harms and different kinds of use cases that's coming through, say, the data protection statute, that's coming through regulating certain kinds of synthetically generated content, again, as we've heard earlier in the webinar today as well. And underlying all of this is also the belief that what you really want to do with AI is harness its potential, and look at it as a lever for one, social good, two, solving a lot of the problems that that the government thinks can be solved in India today, whether it's health, whether it's literacy, whether it's agriculture, whether it's skilling and employment. So across a whole bunch of different use cases, that's very much the idea, that you harness the potential of this technology. Another third key driving factor is that there is a huge and very rich, vibrant startup ecosystem, and you want to do whatever it is possible to to encourage this startup ecosystem to be there and to develop. So that's the overarching sort of regulatory perspective. Now, a few months ago, sometime late last year, we had a set of guidelines that the IT ministry came out with, the federal IT ministry on AI governance guidelines. And I've just put down here the guiding principles that just give you a flavor of how the federal ministry, the federal IT ministry, is thinking about AI regulation in the country. So there is a baseline alignment with, I think, again, as we're seeing in regulators and governments in all parts of the world, that these are core principles that are critical to any kind of conversation on AI regulation and government. But again, not really translating into a horizontal AI statute. The India AI mission is a dedicated sort of arm of our IT ministry that's aimed at, all things AI in the country. But in recent months, we've also seen a change in focus. So it does have a safe and trusted AI pillar that's supposed to look at, sort of safe and trusted AI and what regulation and governance, etc., should look like. But we're given to understand that in recent months, again, the focus of this is now going to be much more on AI compute. So again, an indication of what the direction of the government's thinking is, where its policy priorities are, and how it's thinking about AI generally in the larger sort of ecosystem. If we can move on to the next slide, please. Now, what the government has said, so what we do have currently, as I was saying earlier, is that you've got these three key sites. One is the data protection statute, one is how the conversation on content regulation is shaping up in the country, and you've got guidance from sector-specific regulators about their, in their respective domains and how AI is being used and regulated in their respective domains. Now, and I'll deal with these in order. Now, when it comes to data, we have a new data protection law. The law is fully operational in May 2027. We're still waiting for some guidance from the IT ministry on some specific aspects. Now, in India, data controllers are called data fiduciaries. And there is a category like significant data controllers. There is a category called significant data fiduciaries. All, the few AI related obligations that you do have here, baseline on data protection, it's the same as you would expect in any other data protection statute. You've got notice, consent, purpose limitation, so on and so forth. But heightened obligations when it comes to AI, right? Whether it is, performing algorithmic due diligence, whether it's undertaking a DPIA, whether it is undertaking a data audit. These obligations are only available or befall significant data fiduciaries, and significant data fiduciaries, like significant data controllers, will be determined based on volume, size, scale, sensitivity of data, so on and so forth. So there are a couple of instances in the Data Protection Act that speak to the intersection of AI and data. There is specifically also a call out when it comes to children. You're not allowed to track or profile or behaviorally monitor children. This was a little bit of a touchy topic in India when it came to the Data Protection Act itself, because does that mean that I don't track the activity of children on the platform, so on and so forth. So you do have some obligations that are at the intersection of AI and data. There is no GDPR right equivalent against automated decision making, though. So again, the perspective here is more from the lens here is more obligations that have been put on the service provider in question, and not necessarily a right that the individual has against automated decision making. When it comes to content, now this I think is the site that has seen the most activity when it comes to any kind of conversations on AI regulation in India. Again, not different from what's happening in other parts of the world, especially what we heard about Southeast Asia, for instance. It really picked up steam in the context of elections, because you had deep fakes, misinformation. All of this was proving to be, agnostic of elections also, it is a problem, but it really reached a fever pitch when it came to elections. And it's a big country. There's always some, if not the federal election, there is some important state or the other that's going in for elections. So it constantly tends to be an issue that's always sort of in the news. Now, what happened as a result of different kinds of online harms associated with synthetically generated content, whether it was deepfakes, people were losing money, there were all kinds of frauds, people were impersonating, chairpersons of the National Stock Exchange, people were impersonating startup founders, people lost a lot of money as a result of this. And you had, this barrage of litigation by every major film actor worth their salt going to federal high courts in the country, and wanting injunctions against how their likeness, right? So you've opened the door to personality rights litigation. And you also have very real harms associated with synthetically generated media. Now, as a result, what the IT ministry has done is that it's amended the law, the Information Technology Act. And now we've got labeling requirements for audio and visual synthetically generated information. We've got heightened compliance timelines by internet intermediaries, which are all of your social media platforms, very, very sharp takedown timelines, 3 hours and 2 hours in some, content. From when you get a notice, you have to take it down in 3 hours. In some instances, you have to take it down in 2 hours. If you don't do that, there is a risk that, your safe harbor protections will sort of be taken away. Platforms are expected to employ heightened due diligence requirements, which means that you're supposed to keep a better eye of the kind of content that you have on the platform. There's a lot more proactive monitoring. Grievance redressal needs to happen quicker. So a bunch of amendments related to synthetically generated content. Users are also required to now submit a declaration when you're uploading AI generated content. So that's really been the big piece. And of course, we've got some guidance from our different sector specific regulators. Very recently, our capital markets regulator did say that, we're going to be coming out with guidelines soon. The Reserve Bank of India, which is the banking and finance regulator, has come out with its guidance. This is still at the guidance stage. With the capital markets regulator, some stuff has been hard-coded into law, just in terms of, if you deploy your system, then you are responsible. So that liability piece has been hard-coded, but there are a lot more sort of, guidelines that are in the works by whether it's capital markets, whether it's banking and finance, or even whether it is our telecom sector regulator. And really, perhaps the most interesting critical piece to come out of India in recent months on AI, and I'll stop with this, Sonja, is the issue is actually on the copyright issue. So OpenAI has been in litigation, in India as it has in other parts of the world with ANI. ANI is a news agency in the country. And this is a matter. ANI had taken OpenAI to court and said, you're training your models based on my news articles, and the trial is still ongoing, but this is a specific sort of, temporary injunction that ANI wanted, pending the trial. And the Delhi High Court has opined that, we're not going to restrain OpenAI from using ANI's news articles to train its model. OpenAI's use case in India is protected in Indian Copyright Act by what we call the fair dealing exception. This is similar to the fair use standard in the US in some ways, but not exactly. Fair dealing is actually, it's a lot more list-based. There is a specific case of instances that the law lays down which constitute fair dealing in India, which is a little bit different from the US standard. We're fully expecting, that this is not going to end anytime soon. We're expecting this to be all the way in the Supreme Court. And this is still, again, at the interim injunction stage. We're not yet at, the trial is not done yet. But this is really the most important sort of piece that we've seen come out of India. And I'll pause with that and hand over back to you.
Thank you very much. So we have 5 minutes left. Perhaps my question to the audience, is there anyone who wants to add something from his or her jurisdiction, or do you have any questions to the speakers, or any other comment? So we can use the last minutes for this. No question, no comment, nothing from the audience. No. Perhaps one last question from my side to all of the speakers. It's interesting that we have, on the one hand, this product safety regulation as such, or a kind of product safety regulation like in the EU or in other countries. And we have this regulation of the output and the content in terms of deepfakes or profiling or something else. How do you advise your clients if they intend to develop AI systems and want to operate in different countries? What should be their focus in the first sight?
Well, perhaps I can take this, but only like in two sentences. So I think when it comes to providers, for example, and this can also be smaller companies, for example, startups, if they are downstream providers of AI systems, including high risk downstream providers of high risk AI systems. Then I think there's a very high regulatory burden, for small companies, and so I think they then should think about similar to the time when GDPR kicks in many years ago, or 8-9 years ago, then to, let's say, meet the gold standard, the highest standard.
Okay.
To have something a little bit like a level playing field. So especially because I think most of these business models are online. They provide their product online as a SaaS or similar service, and so and if they are so I think in most cases they are not restricted or limited to 1 or 2 countries, but at least, so for example, they provide their product or services within the EU, for example. So, and then I think in many cases it makes no sense to focus on local laws.
But in other countries, do we also advise on being compliant with the gold standard? So the most comprehensive and strictest rules, which are, I think, actually in Europe.
I would say, Sonja, in general terms, that clients today want to know what is mandatory and what is not. And so while I agree with Valentino, and many times we raise to the clients good practices that we see on the market, that we see what the regulator thinks, the hard question is whether that is mandatory or not, whether it's enforceable, and we have to be honest there, and we have to say what it really is. Some companies will take it because they are more responsible than others. Some other companies will see a cost. So it's hard to reply, but we as counsel have to give them all what we think is important for them to know, and then of course they make business decisions.
Thank you.
I would agree with that as well, but there is also a bit of a geographic consideration for the UK, because so many of our companies are tied up with Europe in some way that ends up being the sort of default standard that a lot of companies are using, because they don't want one practice that fits one area of the world and not in other areas of the world. So it tends to be a little bit more biased towards Europe, I would say, from the UK perspective.
Yeah, I think I'd agree with Diego there as well. I think for us also it depends on what the market is, given that a lot of the the startup ecosystem really works with it could be if your counterparty is in the EU, then a lot of the stuff tends to anyway make its way downstream through contracts. But for whatever work they're doing in the Indian environment, unless it's a very highly regulated use case, right? If it's a sensitive use case, if it's health, if it's banking and finance, then the degree of compliance tends to be a lot more different than anything else. And I think a lot of people now, in the run-up to the data protection law, are also wanting to, for lack of a better word, take advantage of the current regulatory framework before the new Data Protection Act kicks in, which is not as, the compliance requirements are significantly lesser. So I think we're seeing that interesting thing play out in the transition phase as well.
I think for some research it's quite the same. So it really depends. If the investor or clients actually need to comply with the EU AI Act, then it has to be cascaded in. When in Thailand or even in other countries in ASEAN, you don't have that kind of restriction. So it really depends. We have seen quite a lot of the PRC Chinese clients that actually they have their own strict rule, but they can tweak it a little bit more when they want to invest in Southeast Asia. So if that is the case, then it might be the right time because it's not highly regulated right now. And then the cost of compliance from now until like next year or 2 years is still low.
Thank you. So if there is still no question from the audience, I want to give you a short outlook to the AI committee meeting in Copenhagen. So if you're interested in what is going on perhaps in other countries or in the discussion about copyright in AI, Nihao has already spoken about it in her last slide. I think you should join us at the AI committee meeting in Copenhagen, and then we can continue the discussion in person. And I'm really looking forward to it, and want to thank you all for preparing the slides, for preparing this webinar. I thank the people who attended this webinar today, and yeah, thank you also to Margaret for the technical support.
Thank you.
And so then have a good day, good afternoon, good night, what time ever is in your country.
Thank you.
And see you soon.
Thank you. Bye-bye.
Bye.
Bye. Thank you very much.